The United States Congress did something that has never happened before in my experience in criminal cases. It attempted to enter the criminal case as a friend of the court. And the United States Congress basically says in the House of Representatives, we have other evidence against him, Judge, and we want to bring that evidence to you. Now, if I were the judge, I would fine the House of Representatives for filing a frivolous piece of litigation. I'm going to use the language of the streets. The court doesn't give a damn what the Congress thinks about a criminal prosecution. If a member of Congress, in the course of his or her official duties, comes upon criminal evidence about a person who is already a criminal defendant in a criminal case, bring it to the prosecutors. You don't bring it to the judge. The prosecutors will decide whether or not they want to prosecute. There's a clause in the Constitution called the Bill of Attainder Clause. What's a Bill of Attainder? Well, bills of attainder are prohibited, thanks be to God, under our Constitution. The British Parliament used to engage in bills of attainder. As far as I know, they may still do so. A bill of attainder is a legislative determination of guilt. So the Congress would vote as a matter of law, Hunter Biden is guilty, and the Congress would decide what his punishment is. Because the British Parliament often did that to British politicians, and they tried to do it to American colonials, when Madison wrote the Constitution, he made sure that bills of attainder were prohibited. Came ever so close to a bill of attainder, whereby the Republican-controlled House of Representatives, which hates Joe Biden and hates Hunter Biden, and I understand that hatred. I'm not saying I agree with it, but I understand it, wanted to enter a criminal case as if they were the prosecutors. Guess what, guys? The Congress doesn't prosecute. The U.S. attorneys do. If you have dirt or if you have criminal evidence on Hunter Biden or on the father or on anybody, bring it to the appropriate prosecutors. The judge today didn't quite treat the Congress as harshly as I've just suggested to you I would treat them, but she disregarded the House of Representatives' application to become involved in the case. Second thing that happened today was bizarre, and I have heard of this before. A young lawyer on the defense team called the judge's chambers to ask if the judge was going to favorably receive the application of the House Ways and Means Committee chair, what I've just been talking about, the House of Representatives, to enter the case. And whatever this young lawyer said to the judge's clerk thought he, the clerk, was talking to a lawyer for the government rather than a lawyer for the defendant. That may have been an innocent confusion in the phone call and the rush to get this done with all the national press there in the courtroom and right outside the courthouse, or it may have been an intentional and material misrepresentation by this young lawyer for the defense. I sort of doubt the latter, because that could result in her loss of her license to practice law. But whatever it was, the judge, and I don't blame her, I'd be upset about this as well, was upset that her clerk did not know who the clerk was talking to. It's a voice on the phone. Am I talking to defense counsel who wants to know if they have to answer the brief filed by the House of Representatives, or am I talking to the government lawyers who really don't want the Congress involved either? So the court said, let's resolve that issue as well. That's it. That's everything that happened in the courtroom today. You're going to read different versions of this tomorrow. If you go to a website or a newspaper that hates old Joe, you're going to read a different version. But I have given it to you the straight and narrow as I perceive it from among all the experience I've had, which, as I said, is more than 1,000 guilty pleas in my career.